working in the bipartisan spirit that has carried this reauthorization thus far and proceed to pass it without delay. Thank you, and with that I yield the floor.
Mr. President.
The Senator from California.
Thank you very much, Mr. President. At 5:30, we will be voting on the nomination of Paul Watford for the Ninth Circuit Court of Appeals, and I would like to say a few words about him at this time. But before I do, I think members might want to consider the fact that the Ninth Circuit is by far the busiest circuit in the nation. It has over 1,400 appeals pending per three-judge panel. That's the most of any circuit. It's over 2 times the average of other circuits combined. The Judicial Conference of the United States has declared each Ninth Circuit vacancy a judicial emergency. So today, we are, in fact, filling one of the seats, which is a judicial emergency. The candidate is Paul Watford, a Ninth Circuit nominee with stellar credentials and support across the political spectrum. I'm delighted that cloture was vitiated, so the vote will be directly on his nomination, and it is anticipated that he will be confirmed without controversy. Mr. Watford earned his bachelor's degree from the University of California, Berkeley in 1989 and his law degree from UCLA in 1994, where he was editor of the UCLA Law Review and graduated Order of the Coif. After finishing law school, Mr. Watford clerked for Ninth Circuit Judge Alex Kozinski, an appointee of President Reagan's. He then clerked for Justice Ruth Bader Ginsburg on the United States Supreme Court. Following his 2 clerkships, he spent a year in private practice at the prestigious firm of Munger, Tolles & Olson, and then moved into public service as an assistant United States attorney in Los Angeles in 1997. There he prosecuted a broad array of crimes, including bank robberies, firearms offenses, immigration violations, alien smuggling, and various types of fraud. He later served in the major fraud section of the criminal division, focusing on white-collar crime. Among his many cases, he prosecuted the first case of an online auction fraud on eBay in California. During his tenure as a federal prosecutor, Mr. Watford appeared in court frequently, typically several times per week. He tried 7 cases to verdict, and he worked on numerous Ninth Circuit appeals, arguing 4 of them. In one such case, a cocaine dealer had already convinced a state court that a drug seizure had violated his 4th Amendment rights. Mr. Watford prevailed on appeal in forcing the dealer to forfeit over $100,000 in drug trafficking proceeds. In 2000, Watford rejoined Munger, Tolles & Olson, where he is currently a partner. This is one of the premier appellate law firms in California, and Paul Watford specializes in appellate litigation at the firm. Like most major law firms, Munger's docket is dominated by business litigation. Thus, the focus of Mr. Watford's work has been appellate litigation for business clients. For example, he represented Verizon Communications in a consumer class action case. He represented the technology company Rambus in 2 complex patent infringement cases. He also represented Shell Oil on an antitrust case. Mr. Watford and his colleagues at Munger won a 9-0 reversal on behalf of Shell Oil in the Supreme Court. He has also represented numerous other American businesses, such as Coca-Cola and Berkshire Hathaway, as well as business executives and municipal government agencies. In total, he's argued 21 cases in the appellate courts, and he has appeared as counsel in over 20 cases in the United States Supreme Court, so he is well equipped. His extensive experience as a prosecutor and private practitioner, including his specialty in appellate work, will serve the Ninth Circuit extremely well. Mr. Watford is also regarded by attorneys on both sides of the aisle, including conservative Republicans who praise him for his keen intellect and fair-minded approach to the law. He's been endorsed by 2 former presidents of the Los Angeles chapter of the Federalist Society. One, Jeremy Rosen, says that Watford is, and I quote, open-minded and fair, and a brilliant person and a gifted appellate lawyer, end quote. The other, Henry Weissman, says that although, quote, he does not agree with President Obama on many issues, he completely agrees with his nomination of Paul Watford, end quote. So that's a good thing. Daniel Collins, who clerked for Justice Scalia and serves as an Associate Deputy Attorney General in the Bush Justice Department, says that Watford, quote, embodies the definition of judicial temperament, very level-headed and even-keeled, end quote. 32 Supreme Court clerks from the term when Watford clerked for Justice Ginsburg have written in support of the nomination. These include clerks from every justice on the court at that time, including all of Justice Scalia's clerks from that year, as well as several from Justices Rehnquist, Thomas, and Kennedy. I find that quite amazing. A group of over 40 former clerks for Judge Kozinski have also written in support of Watford's nomination. This group includes numerous individuals with unquestionable conservative credentials. Many clerked for Justices Rehnquist, Scalia, Alito, and Kennedy. Several, such as Steve Engel, Charles Duggan, and Ted Ulliott, also served in the Bush administration, including in the White House counsel's office and the leadership of the Justice Department. Watford also has strong support in the business community. The general counsels of leading American corporations, including Google, Mattel, Verizon, Searcorp, have also written in support of Mr. Watford. They say Watford is, and I quote, exactly the kind of individual that any plaintiff or defendant, person, business, or government would welcome deciding their case, end quote. In short, Paul Watford is truly both an excellent and distinguished choice for the Ninth Circuit. He is extremely bright, he is experienced at the trial and appellate level, and in both civil and criminal cases. He is uniquely respected for his intellect and judgment, and he has broad support across the political spectrum and in the business community. Maybe this is the reason why cloture was vitiated. He is not filibusterable, and I really hope that people see the fine and keen intellect that this man is, and he should have a very large vote. If confirmed, he would be one of just 2 African-American active judges on the Ninth Circuit, and the Ninth, by far the busiest circuit in the nation, urgently needs him to begin his service. As I said, the Ninth is a judicial emergency. This will fill 1 vacancy. So I urge my colleagues to vote at 5:30 in 15 minutes for Mr. Watford's nomination. I yield the floor, and I thank the chair.
Mr. President.
Senator from Iowa.
Yeah. Today, we're going to turn to the nomination that the senator from California has just referred to, Paul Watford, to be Circuit Judge, Ninth Circuit. I'm disappointed that the majority leader has brought this nomination to the floor. The reason I say that is that there are at least 10 nominations on the executive calendar that might fall into the category of consensus nominees. 6 nominees on the calendar had significant opposition in committee, and clearly are not consensus nominees. And Mr. Watford falls into this category of not being a consensus nominee. I will oppose Mr. Watford's nomination and ask my colleagues to oppose the nomination as well. My opposition to this nomination is based upon substantive concerns that I have regarding Mr. Watford's views on both immigration and the death penalty. Mr. Watford partnered with the American Civil Liberties Union and the National Immigration Law Center in 2 cases to oppose Arizona's 2010 immigration bill. In the first case, Friendly House, a class action lawsuit, Mr. Watford served as co-counsel for most of the plaintiffs, including the class action representative, Friendly House. The Friendly House complaints attacked the Arizona law on a variety of grounds. He argued the law violates the Supremacy Clause, violates the Equal Protection Clause by promoting racial profiling, that it violates the First Amendment by chilling the speech of non-English speakers, violates the Fourth Amendment, and it violates due process by inviting racial profiling and employing vague definitions of public offense and other statutory terms. In the second case, United States versus Arizona, Mr. Watford served as co-counsel on an amicus brief filed by Friendly House plaintiffs. This brief covers most of the arguments raised in the Friendly House complaint, but in addition, it asserts that Arizona, quote, fails to account for the complexities and realities of federal immigration law, end of quote, because individuals lacking immigration registration documents are put at risk of, quote, constant and repeated criminal prosecution, end of quote. I do not believe that an attorney should be held accountable for the legal positions he advocates on behalf of a client. Of course, there are some exceptions to that general rule. For instance, if the legal positions are far outside the mainstream of legal theory, are frivolous, or indicate an unacceptable level of professional competence. However, in this case, Mr. Watford has not simply argued on behalf of a client. He adopted those legal theories as his very own. On July the 14th, 2010, Mr. Watford gave a speech analyzing the constitutionality of the Arizona law. His speech concentrated on why Senate Bill 1070 is unconstitutional, and he recapped many of the arguments he made in the Friendly House case. Moreover, despite the fact that he discussed his views on immigration publicly, he nonetheless declined to answer many of my questions during his hearing before the Judiciary Committee. For instance, I asked about an argument in his brief that the Arizona statute prohibiting illegal aliens from soliciting work somehow violated the First Amendment. The nominee responded that it would be inappropriate for him to comment on questions related to whether the illegal immigrants were entitled to constitutional protection other than those contained in the 5th, 6th, and 14th Amendments. Again, remember, he had already given a speech on this topic, so I was disappointed that he would not share his views on these important topics. With regard to the death penalty, Mr. Watford assisted in submitting an amicus brief to the Supreme Court in Bays versus Rees on behalf of a number of groups who oppose Kentucky's 3-drug legal injection protocol. In its plurality opinion, the court rejected the argument raised in the brief. Ultimately, Kentucky's 3-drug protocol was upheld on a 7-2 vote in the Supreme Court. At this hearing, that we had for Mr. Watford, and in follow-up questions, Mr. Watford gave the standard response that he would follow Supreme Court precedent regarding the death penalty. Yet, it's very curious to me that he would go out of his way to provide his services to a case that would undermine the death penalty. Furthermore, his concession that he would give consideration to foreign or international law in interpreting the meaning of cruel and unusual punishment clause makes me wonder how he would approach this issue. I have other concerns based on positions this nominee has taken in his legal advocacy as well as some of his presentations. Now, I'm generally willing to give the President's nominees the benefit of the doubt when the nominee on the surface meets the requirements I have previously outlined. But I don't think that this nominee meets these requirements. Finally, Republicans continue to be accused of obstruction and delay when it comes to judicial nominations. This comes even as we have now confirmed 145 of this President's district and circuit court nominees. That, of course, is during a period when we also confirmed 2 justices to the Supreme Court. The last President who had 2 Supreme Court nominees had only 120 confirmations, so this argument of obstruction, of delay, of unfairness just doesn't hold up. I want to remind my colleagues on the other side of the obstructionism, delay, and filibuster which they perfected. The history of President Bush's nominees to the Ninth Circuit provide some very important examples. President Bush nominated 9 individuals to the Ninth Circuit. 3 of those nominations were filibustered. 2 of those filibusters were successful. The nomination of Carolyn Kuhl and William Jerry Myers languished for years before being returned to the President. A 4th nominee, Randy Smith, waited over 14 months before finally being confirmed after his nomination was blocked and returned to the President. After being renominated, he was finally confirmed by a unanimous vote. President Obama, on the other hand, has nominated 6 individuals to the Ninth Circuit. Only one of those nominees was subject to a cloture vote. After that vote failed, the nominee withdrew. If confirmed, Mr. Watford will be the 4th nominee of President Obama nominated to serve on the Ninth Circuit. Those 4 confirmations took an average of about 8 months from the date of nomination. For all of President Obama's circuit nominees, the average time for nomination to confirmation is about 242 days. For President Bush's circuit nominees, the average wait for confirmation was 350 days. Now, given this history that I've spelled out, one might wonder, then, why President Bush and his nominees was treated differently and so much more unfairly than President Obama's nominees. I will put the remainder of my statement in the record. I'll yield the floor, and I would suggest an absence of a quorum.
The clerk will call the roll.
Mr. Akaka. President,
The Majority Leader.
I ask unanimous consent the call of quorum be terminated.
Without objection.
I now ask unanimous consent the cloture motion on the motion to proceed to count number 400, Food and Drug Administration Safety Act, be vitiated at 2:15 p.m. tomorrow, Tuesday, May 22nd. The motion to proceed be agreed to. That a Harkin-Enzi substitute amendment, which is the desk, be agreed to. And the bill as amended by the Harkin-Enzi substitute be considered original text for the purpose of further amendment. And the Majority Leader at that time be recognized.
Is there objection? Without objection.
Mr. President, based on this, we'll have a vote that should start in 5 minutes. That'll be the only vote of the day.
Clerk will call the roll.
Mr. Akaka.
If case,
Without objection.
yield back all time, and I ask the vote to start now.
Without objection.
Ask for yeas and nays.
Is there a sufficient second? There appears to be. There is sufficient second. The clerk will call the roll.
Let's vote now.
Mr. Akaka. Mr. Alexander, Ms. Ayotte, Mr. Barrasso, Mr. Baucus, Mr. Begich, Mr. Bennett, Mr. Bingenman, Mr. Blumenthal. Mr. Blunt. Mr. Bozeman. Mrs. Boxer. Mr. Brown of Massachusetts. Mr. Brown of Ohio. Mr. Burr. Ms. Cantwell. Mr. Cardin. Mr. Carper. Mr. Casey. Mr. Chambliss. Mr. Coates. Mr. Coburn. Mr. Cochran. Ms. Collins. Mr. Conrad. Mr. Coons. Mr. Corker. Mr. Cornyn. Mr. Crapo. Mr. DeMette. Mr. Durbin. Mr. Enzi. Mrs. Feinstein. Mr. Franken. Mrs. Gillibrand. Mr. Graham. Mr. Grassley. Mrs. Hagan. Mr. Harkin. Mr. Hatch. Mr. Heller. Mr. Hoven. Mrs. Hutchison. Mr. Inhofe. Mr. Inouye. Mr. Isaacson. Mr. Johans. Mr. Johnson of Wisconsin. Mr. Johnson of South Dakota.
Thank you.
Mr. Carey. Mr. Kirk. Ms. Klobuchar. Mr. Cole. Mr. Kyle. Ms. Landrieu. Mr. Lautenberg. Mr. Leahy. Mr. Lee. Mr. Levin. Mr. Lieberman. Mr. Lugar. Mr. Manchin. Mr. McCain. Mrs. McCaskill. Mr. McConnell. Mr. Menendez. Mr. Merkley. Ms. Mikulski. Mr. Moran. Ms. Murkowski. Mrs. Murray. Mr. Nelson of Nebraska. Mr. Nelson of Florida, Mr. Paul, Mr. Portman, Mr. Pryor, Mr. Reed of Rhode Island, Mr. Reed of Nevada, Mr. Risch, Mr. Roberts, Mr. Rockefeller, Mr. Rubio, Mr. Sanders, Mr. Schumer, Mr. Sessions, Mrs. Shaheen, Mr. Shelby, Ms. Snow, Ms. Stabenow, Mr. Tester, Mr. Thune, Mr. Toomey, Mr. Udall of Colorado, Mr. Udall of New Mexico, Mr. Vitter, Mr. Warner, Mr. Webb, Mr. Whitehouse, Mr. Wicker, Mr. Wyden, Senators voting in the affirmative: Blumenthal, Cardin, Durbin, Feinstein, Inouye, Reed of Rhode Island, Reed of Nevada, and Stabenow. Senators voting in the negative: Cochran, Enzi, and Johans. Mr. Baucus. Mr. Baucus, aye. Mr. Conrad. Mr. Conrad, aye. Mr. Carper.
Brown votes.
Mr. Carper, aye. Mr. Pryor. Mr. Pryor, aye. Mr. Brown of Massachusetts, aye. Mr. Grassley. Mr. Grassley, no. Mr. Manchin. Mr. Manchin, aye. Mr. Burr. Mr. Burr, no. Mr. Lee. No. Mr. Lee, no. Mr. Roberts. Mr. Roberts, no. Mr. Isaacson. Mr. Isaacson, no. Mr. Begich. Mr. Begich, aye. Mr. Bozeman. Mr. Bozeman, no. Mr. Kerry. Mr. Kerry, aye. Mr. Leahy. Mr. Leahy, aye. Mr. Sanders. Mr. Sanders, aye. Mr. Whitehouse. Mr. Whitehouse, aye. Mrs. Hagan. Mrs. Hagan, aye. Mr. Alexander. Mr. Alexander, aye. Mr. Webb, aye. Mr. Sessions. Mr. Sessions, no. Mr. Rubio. Mr. Rubio, no. Mr. Coons. Mr. Coons, aye. Mr. Thune. Mr. Thune, no. Mr. Bingaman. Mr. Bingaman, aye. Mr. Corker. Mr. Corker, no. Mr. Nelson. Mr. Nelson of Nebraska, aye. Mr. Barrasso. Mr. Barrasso, no. Mr. Kyle. Mr. Kyle, aye. Mr. Lieberman. Mr. Lieberman, aye. Mr. Paul. Mr. Paul, no. Mr. Coburn. Mr. Coburn, no.
Mr. One vote.
Mr. Coates. Mr. Coates, no. Ms. Cantwell, aye. Mr. Brown. Mr. Brown of Ohio, aye. Ms. Collins. Ms. Collins, aye. Mr. Akaka. Mr. Akaka, aye. Mr. Risch. Mr. Risch, no. Mr. Crapo. Mr. Crapo, no. Mr. Lugar. Mr. Lugar, aye. Mr. Shelby. Mr. Shelby, no. Mr. Warner. Mr. Warner, aye. Mr. Casey. Mr. Wyden. Mr. Wyden, aye. Mr. Johnson of South Dakota, aye. Mr. McConnell. Mr. McConnell, no. Mr. Udall. Mr. Udall of New Mexico, aye. Mr. Hatch. Mr. Hatch, no. Mr. Cornyn. Mr. Cornyn, no. Mr. Cole. Mr. Cole, aye. Ms. Ayotte. Ms. Ayotte, no. Mr. Blunt. Mr. Blunt, no. Mr. Tester. Mr. Tester, aye. Mr. Moran. Mr. Moran, no. Mrs. Boxer. Mrs. Boxer, aye. Mr. Wicker, no. Mr. Johnson of Wisconsin, no. Mrs. Gillibrand. Mrs. Gillibrand, aye. Mrs. Hutchison. Mrs. Hutchison, no. Mr. Bennett. Mr. Bennett, aye. Ms. Murkowski. Ms. Murkowski, aye. Ms. Snow. Ms. Snow, aye. Ms. Klobuchar. Ms. Klobuchar, aye. Mr. Toomey, no. Mr. Nelson. Mr. Nelson of Florida, aye. Ms. Mikulski. Ms. Mikulski, aye. Mr. Casey. Mr. Casey, aye. Mr. Graham. Mr. Graham, aye. Ms. Landrieu, aye. Mr. Merkley, aye. Mr. Inhofe, no. Mr. Franken, aye. Mr. McCain. Mr. Rockefeller, aye. Mr. Udall of Colorado, aye. Mr. Harkin, aye. Mrs. Shaheen, aye. Mr. Lautenberg, aye. Mr. McCain, aye. Mr. Hoven, no. Mr. Portman, no. Mr. Levin, aye. Mr. Chambliss. Mr. Chambliss, no. Mr. Menendez. Mr. Menendez. Aye. Mrs. Murray. Mrs. Murray, aye. Mr. Schumer. Mr. Schumer, aye.
Are there any senators wishing to vote or to change their vote? Seeing none, the yeas are 61, the nays are 34. The nomination is confirmed. Order, the motion to reconsider is made and laid upon the table. The President will be immediately notified of the Senate's action, and the Senate will resume legislative session.
Madam President,
The Majority Leader.
I ask unanimous consent to cloture motion on the motion to proceed to calendar number 400.